Good afternoon, and thanks for joining us for a Tax Practitioners Board webinar. My name is Ashley Dowsard, and I'm joining you from Ngunnawal and Ngambri country. I respectfully acknowledge the traditional owners and custodians of country throughout Australia and their continuing connection to land, waters, and community. I'd like to pay my respect to them and their cultures and elders past and present. To begin, I have a few quick housekeeping messages. First, to access today's slides, you can visit our Webinar Resources Hub at tpb.gov.au/webinar-hub. We'll also email you a copy of the slides following the webinar. Today's webinar counts towards your continuing professional education or CPE, and you can claim 1 hour for attending. In relation to claiming your CPE, we will issue an attendance certificate to those of you staying online for the webinar today. In today's webinar, we'll explain the new guidance on our 2 new code items relating to disqualified entities. We'll also go through a few scenarios and case studies before we dedicate some time at the end to answering your questions. In that regard, we have Daniel and Georgia from our policy and legislation team joining us. They'll be responding to your questions as we go in the Q&A. To find the Q&A, simply hover your mouse over the screen and a range of icons will appear on the bottom of your screen. You can also use the chat function to speak to other participants. We won't be monitoring the chat closely throughout the presentation, so if you need a response from us, be sure to use the Q&A. To disable any of these functions, simply hover over the relevant icon and unselect Show Preview. Also, please remember to keep your comments courteous and professional. Before we begin, I'd like to introduce our speaker for today, TPB board member Deborah Anderson. Welcome, Deborah. Over to you to get us started.
Thank you, Ashley, and hi, welcome everybody. I hope you managed to have a break if you were with us this morning. All right, we're going to talk about codes 15 and 16, which are our 2 new code items that started on the 1st of January 2024. So here we go. We've got under code item 15, you must not employ or use the services of an entity that you know or you ought reasonably to know is a disqualified entity to provide tax agent services, which of course includes tax and BAS agent services on your behalf, unless you have obtained TPB approval. Code item 16 prohibits you from having certain arrangements with an entity that you know or you ought reasonably to know is a disqualified entity in connection with the provision of any tax or BAS agent services. So what does that all mean? And that's what today's webinar is about. So firstly, I'm going to quickly clarify what I mean when we say you know or ought reasonably to know. The phrase or know or reasonably to know, as you can see, has 2 elements. The first is know, which means that you've got actual knowledge of an event or, the existence of it. The second, the phrase ought reasonably to know, extends to where you've got the existence where the matter could be discoverable or found by a reasonable person in the same position as you, same qualifications as you, same type of experience as, you would be expected to have as a tax or BAS agent, and making reasonable inquiries. So a tax practitioner must therefore take reasonable steps and make reasonable inquiries to determine whether an entity is a disqualified entity. And we'll talk about what we consider to be reasonable steps and reasonable inquiries throughout the presentation. So what or who can be classified as a disqualified entity? There are a whole range of different types of entities for the purposes of this provision. And we're not going to go through the exhaustive list of types of entities, but the common ones include individuals, companies, partnerships, trusts, superannuation funds. However, to be a disqualified entity, the entity cannot be a current registered tax or BAS agent or a qualified tax relevant provider. So an entity will be a disqualified entity if within the last 5 years, the entity has been convicted of a serious tax offence, convicted of a serious offence. So that's one that under Australian law, is punishable by imprisonment for a period exceeding 12 months. And of course, whether you've been convicted of an offence involving fraud and dishonesty, whether you've been penalised for being a promoter of a tax exploitation scheme, or if you've been penalised for implementing a scheme that has been promoted on the basis of conforming with a product ruling in a way that is materially different from that described in the product ruling. If the entity has become a undischarged bankrupt, so that means even if they're no longer an undischarged bankrupt, or whether the entity has gone into external administration, even if they're no longer in external administration. If they've been found to have contravened the TASA through an investigation by the TPB or by a court, had sanctions imposed by the TPB for failing to comply with the Code of Professional Conduct, had their registration or renewal application rejected, and this is an important one because most people don't think about it. So if they've had their registration or renewal application rejected for eligibility reasons other than failing to meet education or experience requirements, and often those will be things like somebody who's maybe been found to be not fit the person, and therefore they haven't been allowed to register as a tax or BAS agent. Other disqualified entities are where the entity has had their registration due to an event which affected continued registration having occurred, and that often is something like PII insurance, for example. They've ceased to meet a tax practitioner registration requirement or breached a condition of registration. So those things that can occur in those cases, fit and proper requirements, no supervising agent, no PII, those types of things. An entity provides a tax agent service on your behalf if they are required to be under your supervision and control in providing the service. So the type of entities employed or used to provide tax agent services on your behalf can include employees, associates, contractors, and Code Item 15 does not apply to entities that provide administrative or, that kind of support to a tax practitioner. So that could be someone, like someone who answers the telephone, those types of things, or somebody who does tax agent services for no fee or reward. So arrangements that are prohibited by Code 16. Code 16 prohibits you from having arrangements with a disqualified entity in connection with the provision of tax or BAS agent services. The term arrangement is broadly defined and can include any arrangement, an agreement, an understanding, handshake, a promise, an undertaking, whether it's express or implied, whether or not it's even legally enforceable or not, between a registered tax practitioner and the other entity. Code Item 16 is intended to prevent arrangements where the disqualified entity is effectively operating through a registered agent. And this can often occur where the disqualified entity is acting as controlling mind, for want of a better term, of the registered tax practitioner and provides the tax agent services while effectively being unregistered and using the tax practitioner's registered agent credentials. So circumstances which may constitute an arrangement for the purposes of Code 16 can vary significantly, and they are considered on a case-by-case basis. Unlike Code 15 arrangements, Code 16 arrangements are prohibited and cannot be approved by the TPB at all. So let's have a quick example. So that puts all, because there's a lot of entities in this, right? So it can be a bit confusing. So we'll put it into context. If we have a look at this situation, we've got a registered tax practitioner who enters into an arrangement with a disqualified entity who provides services using the registered tax practitioner's registration number and uses their access credentials to OSFA, etc. So we have Kim. So Kim's been terminated by the TPB 9 months ago for ceasing to be a fit and proper person, which makes Kim a disqualified entity. Kim's still wanting to work though, and so Kim enters into an arrangement with Matt, and Matt's a registered tax practitioner, and Kim enters into the arrangement in connection with providing tax agent services to Matt. The arrangement involves Kim using Matt's tax agent registration number and Matt's ATO online services access credentials to lodge income tax returns. Now, Matt is not otherwise involved in the preparation or lodgement of these income tax returns. He doesn't provide any supervision to Kim, and is not in control over the services provided. But Matt does receive a payment from Kim based on the amount of fees she renders each month. Matt does not make any reasonable inquiries about whether Kim is a disqualified entity prior to entering into the arrangement, and he fails to check on the TPB register to see whether Kim has been previously terminated or sanctioned by the TPB. In this case, Matt is in breach of Code 16. He may also be in breach of other items of the code and civil penalty provisions as well, but we're not really going into that here. But Kim will also be in breach because she failed to notify Matt that she's actually a disqualified entity. So how do you identify who is a disqualified entity? So you must take reasonable steps and you must make reasonable inquiries to determine if an entity you employ or that you use to provide tax agent services on your behalf is a disqualified entity. We expect these steps and inquiries to include information gathering processes such as when you're onboarding new employees or if you're contracting out, that you do some due diligence on each of those. What we would expect that you did in the first instance is we would expect as a very first step, you would check if the entity or the person, and remember when we talk entity, we're talking about a person or a company or a partnership or a trust, is registered with ASIC or was previously registered with ASIC. We would also expect that you would look up the public register to check whether the entity or person, what their registration status is with the TPB, and including whether or not they had been terminated by us or sanctioned by us in the past. You can also use ASIC's Financial Advisors Register to check if the entity is currently registered as a qualified tax relevant provider. If the entity is currently registered as a tax practitioner or as a qualified tax relevant provider, then the entity is not considered a disqualified entity as of right now. A search of the register is only the first step, though, in determining whether an entity is a disqualified entity. And to ensure that you've taken all the reasonable steps and made all the reasonable inquiries, you also need to go and do a couple more steps, which we'll go through now. So if the entity in question is not a currently registered tax practitioner or qualified tax relevant provider, you need to undertake an additional step, which includes undertaking appropriate proof of identity checks on the entity, which meet the minimum requirements outlined in our client verification process, which we had a webinar on, I think it was last week, if you wanted to go back and watch that. You need to discuss the requirements of code items 15 and 16 with the entity or their authorised representative and obtain written confirmation from them that they have not had a disqualifying event within the last 5 years. You'll need to get written confirmation using our disqualifying events declaration and consent form. You need to retain a copy of this completed form for at least 5 years after ceasing to employ or use that entity in any arrangement. So ensure that you've got a written contract or an arrangement in place with that entity. You need to also make sure that in that contract it says that the entity is required to notify you should a disqualifying event happen and ensure that if the individual or entity becomes a disqualified entity, they must not provide tax agent services on your behalf unless and until you have received TPB approval. So we do recommend that you get independent legal advice in respect to your obligations, particularly under employment and contract law. Now, where you already have or you already are employing someone or using another entity to provide tax agent services, you need to follow the steps outlined in 1 and 2. And, you know, if you haven't done proof of identity checks on those employees or those contractors in the past, now's the time to do it. But if you have done it, you can skip that step. If you are employing, so that is you're using or you're in an arrangement with somebody or an entity that is already a disqualified entity to provide tax agent services on your behalf, you need to make sure that that provision stops and you need to apply for permission from the TPB now before that entity or that person can work on tax agent services for you again. So what that would mean is if you've got, say myself, Deborah is your employee, you find out I'm a disqualified entity, you need to reassign me to non-tax agent services until you get that permission. If you do not seek TPB approval, or if we reject the application to employ that disqualified entity, you will then be in breach of code item 15 if the entity provides tax agent services on your behalf. So again, you may wish to cease employing or contracting with the disqualified entity, and in those circumstances, you do need to seek independent legal advice in respect to your obligations under employment and contract law. So again, it's probably a good time, if you haven't had a chance to update those, to get those looked at now. So what happens after the transitional period? Well, the transitional period applied between the 1st of January 24 and the 31st of December last year, 2024. And that was to allow tax practitioners a reasonable time to understand what disqualified entities and the new requirements of Code 15 and 16 were, and also to apply to the TPB for permission. So those transitional arrangements ceased from the 1st of January 2025. So now, to comply with Code Item 15, you must not employ or use a disqualified entity to provide tax or BAS agent services on your behalf without having TPB written approval. To comply with Code Item 16, you must not provide tax agent services in connection with an arrangement where a disqualified entity operates through you as a tax practitioner. So a disqualified entity must notify you in writing of their disqualified status before they are used or employed to provide tax agent services on your behalf, or before they enter into an arrangement with you in connection with providing tax agent services. If a disqualified entity is currently used or employed to provide tax agent services on your behalf or in an arrangement with you, they must also notify you within 30 days of when they become aware or ought to have become aware that they are now a disqualified entity. So a disqualified entity can provide this notification by completing a form that's on our website. It's called a Disqualifying Events Declaration and Consent Form, and they must provide that to you. If they fail to give you that notice, the disqualified entity may be subject to civil penalties. And the maximum penalty that can be applied is 250 penalty units for an individual and 1,250 penalty units for a body corporate. And the current value of a penalty unit is $330 per unit. So you can do the math. So as I've discussed, if you want to employ or use a disqualified entity to provide tax agent services on your behalf, you must apply to us for approval in order to comply with Code Item 15. So to obtain written consent from us, you need to complete the Disqualifying Events Declaration and Consent Form. And you need to get the Disqualified Events Declaration and Consent Form, and you need to provide that to us with your application. To lodge an application, you simply log into your My Profile on the TPB website, and you access the approved form, provide all the relevant information to us in support of your application, and we will ask for things like, what are the reasons why the entity is a disqualified entity, the circumstances of the entity that led to it becoming disqualified, the role that the person or entity would be performing for your practice, the reasons why the entity's ability to perform their role or their proposed role to an appropriate standard of professional and ethical conduct would not be affected, and any other relevant considerations that you think might be appropriate, supervision, those types of things. We, being the TPB, must make a decision on your application within 60 days of receiving your application, unless we have agreed with you for a longer period, and we'll always discuss that with you if there's an issue. Once we have made a decision, we will notify you of our decision in writing, and if we reject your application, we will provide you with the reasons why we have rejected the application. If we don't make a decision within 60 days or the agreed extension period, the application is taken to be rejected. If your application is rejected, you can apply to the Administrative Review Tribunal for a review of our decision. Now, if breaches are found for Code 15 or 16, our Board Conduct Committee may impose one or more sanctions. The sanctions that we can impose are a written caution, an order requiring you to do something specific, such as undertake a course of education, such as like a course in the TASA, or ensure that you work under the supervision of another registered practitioner, or that you need to notify all of your clients in writing about the board's findings of your misconduct. The board can also, for more serious breaches, suspend your registration for a period of time or terminate registration with a prohibition period on reapplication for a maximum of 5 years. A breach of Code 15 or Code 16 can also impact on non-code items such as the fit and proper registration requirement, which is necessary to maintain your registration as a tax or BAS agent. But it can also impact other code items, such as Code Item 1, which is acting with honesty and integrity, or Code Item 7, which is relating to ensuring tax agent services that are provided or provided on your behalf are provided competently. So let's have a look at another couple of case studies just to put all of that into perspective. So case study 1, we have Betty. And Betty is a registered tax practitioner. She wants to employ Brian to provide tax agent services on her behalf. Brian is not a registered tax practitioner or a qualified tax relevant provider. Brian notifies Betty that he is a disqualified entity. And this could be, for example, that Brian is a undischarged bankrupt, for example. And so he advises Betty that he is a disqualified entity. Betty advises Brian that she cannot employ him to provide tax agent services on her behalf until she has received approval from the TPB to do so. So with Brian's consent, Betty makes an application to the TPB in the approved form for Brian to provide tax agent services on her behalf and assist her in her practice. In her application, Betty explains the reason why Brian is a disqualified entity and what were the circumstances around him becoming a disqualified entity. The type of role that Brian would be doing in Betty's practice and the supervision that's around that. The reasons why Brian, being a disqualified entity, is not relevant to his ability to perform the proposed role to the appropriate standard of professional and ethical conduct. And again, that goes around a lot of it to do with supervision and systems. And any other additional facts that she considers relevant to the TPB's consideration of her request for approval. Now, even with giving the TPB all of that information, should still attach supporting documentation if it's appropriate or available. Based on the information Betty provides in her application for approval, her request to employ Brian to provide tax agent services on her behalf is approved by the TPB. And so Brian can now commence working for Betty's practice as an employee, providing tax agent services on her behalf. And in this case, Betty has met all her obligations and has not breached Code Item 15. So I hope that makes it a little bit clearer. We'll have a look at the next case study. And in this one, we have Frank. And this one's relating to Code Item 16. So here we have Frank, who had his registration terminated by the TPB 2 years ago for ceasing to be a fit and proper person, which makes him a disqualified entity. Bonnie, who is Frank's wife, and is therefore aware of his termination, Bonnie becomes a registered tax practitioner herself about a year after Frank was terminated. And at the same time, she registers a company called Bonnie's Tax Proprietary Limited as a tax agent. Bonnie is the company's sole director and sole supervising agent. It comes to our attention, or TPB's attention, that Frank is actually meeting with Bonnie's clients in the office and he's preparing their tax returns. These clients have only interacted with Frank, and Frank is also contacting the ATO on behalf of clients to arrange lodgement deferrals and debt payment plans. Bonnie's Tax Proprietary Limited is in breach of Code Item 16, as Bonnie, the sole director of Bonnie's Tax Proprietary Limited, is aware that her husband's registration was terminated and that Bonnie's Tax Proprietary Limited is providing tax agent services in connection with an arrangement with Frank, a disqualified entity, without applying to the TPB for permission first. We have another case study here, and in this one we have Cheryl, and Cheryl is a disqualified entity. Cheryl sought to enter into an arrangement with James, who is a registered tax practitioner, in connection with the tax agent services provided by James. So James undertook proof of identity inquiries in respect to Cheryl. He discussed the disqualifying events that could prevent her from entering into an arrangement with him. And James receives a written declaration from Cheryl that none of these events apply to her. James has also done a search of the TPB register and the ASIC register, and Cheryl's details did not appear on either of those. James ensured that the arrangement with Cheryl includes terms that require Cheryl to immediately disclose whether she is or whether she becomes a disqualified entity. During the period of the arrangement, James discovers that Cheryl is now a disqualified entity. Upon discovering that, James immediately ceases providing tax agent services in connection with the arrangement with Cheryl. So James has undertaken all the reasonable inquiries and he has met the TPB's minimum requirements despite Cheryl being a disqualified entity. So Trevor, let's hand over to you now and let's have a look at some of the questions that we may have received already.
Somebody asked, what's the purpose of DE requirements?
Okay, so the purpose of the DE requirements, that they were the measures that are intended to, to maintain the integrity of the tax system as a whole, reduce tax fraud and evasion, and protect consumers by ensuring that those entities, those people employed or used as contractors by tax practitioners have the appropriate ethical and professional attributes to be engaged in the tax profession.
Thank you. Another one that's come in. When do disqualified entity requirements apply for new registrants and those renewing their registration?
So code items 15 and 16 came into effect on the 1st of January 2024. And we did have that 12-month transitional period where, to get everybody up to date on what those new rules were, have time to put in their applications if required and get them approved. The transitional provisions have finished now. So now, and that was on the 31st of December. So from the 1st of January this year, they're all live in real time. We would expect, or we do expect, that you're covering now all those requirements with your employees, contractors, etc.
Thanks, Deborah. This is, again, I've seen 2 or 3 questions similar to this one. How do I seek approval from the TPB to employ or use a disqualified entity to provide tax agent services on my behalf?
Okay, so you must use our approved form, just like a BAS form. This is an approved form. So you access it through the TPB website under, you need to log in under My Profile, and then there is a DE application form that you can fill out. So the application form has to be accompanied by all the relevant information, obviously, that's on the form, any attachments, any, reasons for why they're a DE, or, all those sort of circumstances that are around it, so that we can make a decision whether or not that person is appropriate to be still working in the tax and super system. They also need to give you written permission. The DE needs to give you written permission to be able to do that. And you can get their consent by using a form called the Disqualifying Events Declaration and Consent Form, which is on our website as well.
So here's another question that's come in from a guy called John. Should I get all my current employees to sign a declaration to confirm they're not disqualified?
Yeah, you should. And this is, you should be looking at updating your employment contracts or subcontractor contracts as well, to make sure and do some training with all your staff that they are aware of what the obligations are and what your obligations are, and what the consequences are for both parties if that isn't done. But yeah, definitely have a chat with them. Make sure you get written information that says no, they're not a disqualified entity, and if they are, go through the steps that we talked about earlier.
Perfect, thank you. Here's another one. What if I become a disqualified entity while I'm engaged by a tax practitioner?
Okay, so, that may happen with people. I mean, one of the common things that I've seen come through is that somebody's a disqualified entity because, they're fallen behind in their PTOs. So that's been a common thing I've seen. So in those cases, we've terminated them, and they are no longer registered, but they might be working for somebody. You do need to tell your employer, or if you're contracting to another agent, you do need to let them know within 30 days after you become aware, or where you should be aware that you are a disqualified entity. And of course, as I said, PTOs is a really common one that I see, and also, agents or ex-agents that have gone into bankruptcy. So, let your employer or, the company you're contracting to, let them know as soon as you know. You've got 30 days, fill out the forms and get the application into us. But it will mean that you will need to stop doing that work while it's being assessed by the board.
Brilliant. Thanks, Deborah. Here's another one. How many years must pass before an entity is no longer a disqualified entity? So what's the period of time?
It's 5 years.
Okay. And what services, I think again within the policy itself, what services can be classified as administrative?
Well, if you're answering the telephones, that's administrative. Maybe, and I mean, it really does depend, but I'm thinking maybe something like IT, that's administrative. But if they're actually working on client tax return or, even compiling information, I would, you'd probably consider that they are now actually providing a tax service within your business that you're relying on there. If you're unsure, we've got some great resources on our website. You know, there's actually so much on our website and in a lot more detail. And we've also got a stack of case studies so that, and we're trying to put them together as we see them come through as well, so that we can say, this is what we're seeing in real life. And some of the situations where we've said yes, and some of the situations where we've said no.
Excellent. Just scrolling through so we've had a whole load of Q&As, so thank you very much for people who've asked questions. We've got one here. Do we need to get TPB clearance if the disqualified individual works under supervision?
Yes. So they should be working under supervision anyway. You know, unless they were a supervised agent. But yes, if they're working under supervision, they are still providing tax or BAS services within your firm, whether that be, you know, as a contractor or as a employee, and they are still a disqualified entity.
And I think this will be the same answer, but it's a good segue into the same kind of question. Does disqualified entity obligations apply to consultants that we sometimes use for specialist tax advice?
Absolutely. That's a really good question. So if you were getting R&D, tax advice, or even quantity surveyor, anything that's a specialist area, you do need to make sure that they are not a DE first, or get permission.
Okay. Here's another one that's come in. Our office employs a staff member that is a registered tax agent. This employee is currently not disqualified, i.e. has a perfect TPB record. How do we know if this person becomes disqualified for some reason? Are we required to regularly search and check the employee's registration status?
Look, it's this person, you're talking about them being a registered tax agent. They need to let you know if they are no longer a registered agent and become a disqualified entity. Would it be a good process that, you know, periodically you do a check of the TPB website? Probably. You know, is that reasonable?
Question from Melanie. Do these requirements apply to offshore contractors?
Yes, they do. They apply to anybody that is providing you tax and BAS agent services. So you should be doing your due diligence, I guess, for want of a better term, on everybody that works for you. And I mean, you really should be considering the checks that you do on all employees and contractors that have access to sensitive information within your business. You know, police checks even, you know, they may not necessarily have a record with the TPB, but they might have, we often, you might hear in the news or something of employee bookkeepers who have been done for fraud, you know, those types of things. So you just never know.
And one from FISA. Is the different disqualification periods depending on the reason someone was disqualified?
So what was that again?
Sorry, is there different disqualification periods depending on the reason someone was disqualified?
No. So it's 5 years. So everyone, if one of those events has happened in the previous 5 years, you're a disqualified entity. But just because you're a disqualified entity doesn't necessarily mean you can't work, right? So, for example, we had one the other day where, you know, the person had gone into bankruptcy. They'd had a milk bar or, I don't know, something, right? And now they've given that up and now they were going to work for, you know, one of the companies. And they said, you know, this person's bankrupt. We want to employ them, blah, blah, blah. And, we approved that. So just because, you've got those types of issues in the past doesn't mean we're necessarily going to say, no, you can't work. But obviously, when you look at things like the more deceptive ones, serious, we're looking at fraud and, tax, those sort of really high level tax offences, there might be a different situation.
And again, I think that's a really good segue. Pratik asked, and again, it's a similar answer. Pratik asked, can a disqualified entity be employed to do other clerical work? But then Pratik adds, such as preparing financials, bookkeeping, etc.
Well, they're still providing some of the tax agent services, right? So some of that's kind of borderline, Pratik. I think on the balance of probability there, I'd say they probably are providing services. But if they're providing really, administrative tasks, so I can't think of one. My practice is too small. You do everything here. But, it would have to be not tax or, bookkeeping type related, I think is relevant there.
Thanks, Deborah. And then a question from David. What does a TPB look at in deciding whether to approve or reject an application?
Great question. We actually look at every single application on its individual merits. And when we do that, we look at both the entity that's applying to have the DE work for them, and we're looking at the DE and what were the circumstances of the DE and why did that happen. We had one the other day, I think, where somebody had gone into bankruptcy again, but it was a marriage split, and things had just got really ugly. So we look at the circumstances around it. We look at the threat, because, the TPB, our main focus is actually not necessarily on tax practitioners, it's on consumer protection, which is what our focus is all about. So, we're looking at whether there is what the person will be doing or the entity will be doing, what were the reasons behind their situation, what were the offences, if there were offences, how long ago was it, has there been any remediation done? Again, we had one the other day where somebody had gone into bankruptcy, and they actually ended up getting out of the bankruptcy. They paid it all off within 3 months or 4 months or something, So that had happened, but then they remediated it quite quickly as well. But there's still a DE for 5 years, And we also look at the entity that's wanting to employ them, or the tax agent or BAS agent wanting to employ or bring them on, because the things we're looking for there are, what are the tasks you're going to get them to do? What are the supervision? Is it remote? Is it sitting next to the tax agent? Or, are they going to be dealing with clients? What's the autonomy there? All of those important facts. We don't just have a blanket, this tick, that cross.
Oh, the devil's in the detail, isn't it?
It is in the detail, and we do try really hard to be as absolutely fair as possible. We don't want to stop somebody being able to earn a living because something really horrible had happened that was out of their control, or even, it was just unfortunate. And especially if they've got a tax debt, we want them to be able to pay it off. You can't pay it off if you can't get a job. So, there's a whole bunch of circumstances that we take into consideration, and we recognise that we're dealing with people, and, that's really important to us.
Thanks, Deborah. And another Deborah, someone of the same name, asked, just to clarify, I deal with an Australian-based outsourcer that runs their own company. Am I obligated to ensure all of their employees are not disqualified?
Well, that's a really good question, Deborah Pink, and I would love that name myself because pink is my favourite colour. It depends. And when I say it depends, I think there is an example on our website actually where an agent outsources some of their work to another practitioner, but there's actually one or two employees that are working on that company. So say your outsourced provider has 100 people working for them, but only one or two actually work on your account. You would check those one or two people. And if there was a registered agent working there, for example, I mean, you'd be wanting to do your due diligence on that, but definitely the people that would be working for you or on your work, you would want to be getting that checked. Every single employee in the firm, I mean, it'd be very unusual to have that situation, but that it all comes down to the actual situation. Who's working on it? If they're not touching anything to do with your business and they're not providing any tax or BAS agent type services to your business, that person is probably not required to be checked.
Thank you, Deborah. Now, I'm assuming this is a hypothetical, but I've been asked, if a new entity takes over the disqualified agent's business, can the disqualified agent be employed on a short-term basis?
You have to apply to the TPB because that person is a disqualified entity. So, I mean, that's what it all comes down to.
No worries, thank you. And then there's one from Justine. I'll wrap these two together because they're quite similar. There's one from Justine and one from an anonymous attendee. What if the person gives up their registration and the other one says, yes, what if they voluntarily cancel or don't renew prior to a disqualification event? What happens prior to an investigation? They're similar questions.
Yeah. So, but they're slightly different. So I think I'm just trying to find Justine's because I had it and then my screen.
Okay. So she asked, what if a person gives up their registration prior to the TPB concluding an investigation?
Okay.
So I think, one's concluding and one's prior. So.
Okay. So with if somebody surrenders their registration, they're actually a disqualified entity, right? If their registration lapses, they're not a disqualified entity. So maybe that's enough for that question. So if they've given up, if they've surrendered during, just before, just after, they've surrendered, and most likely they've surrendered so that they don't get terminated, they're still a disqualified entity. So surrendering is also makes you a disqualified entity.
Yeah. Okay. I can still see we've still got some coming in, but as I say, please, apologies for anyone whose question we didn't get to. We got through an awful lot of questions today, and a big thank you to Deborah for sharing all of your insights, and also to Daniel and Georgia. We hope you found the webinar beneficial, and it can count towards your CPE, and you can claim 1 hour for attending today. If you'd like more information, obviously visit our website, tpb.gov.au. You can also find us on LinkedIn and Facebook. I'd encourage people also to subscribe to our YouTube channel. We've got a few thousand subscribers there, and that way you receive notifications when we post new videos. Let's say for people who haven't attended any or many of our webinars before, we record them all, and we have a comprehensive library of webinars available for you to view at your leisure. And of course, if you watch them on YouTube, you can still claim CPE for viewing those videos. We also have a newsletter that goes out each month called TPB News. That's really useful to follow if you're looking at perhaps new policy changes or information about the sector generally. And please subscribe to that tpb.gov.au newsroom. It's up on the screen there. Before we finish up, I'll be launching an exit survey, so please take the time to complete the exit survey. It only takes a couple of minutes, and your feedback will really help us to improve our webinar and lets us know of topics that are of interest. ones that we're keen to deliver off. Survey will open once you in your browser once you leave the webinar. And once again, thank you ever so much for joining us today, and we hope to connect with you again soon. Thank you very much.
Thanks, Trevor. Thank you, team.